In the Logan Paul / Coffeezilla defamation case, we just talked about the big evidence reveal that Logan Paul doesn't want the public to see. Specifically, these are details of the investigations by the SEC and the FBI looking into Logan Paul directly for his involvement in the CryptoZoo and Dink Doink projects. Logan Paul was so afraid of everyone seeing this that he filed a motion to preserve confidentiality and then not long after withdrew that motion for some unknown reason. In the last video, we went over the new details that we learned about all of this from recent filings. And in this video, we're going to go over why I think this is absolutely terrible for Logan Paul's case, particularly if this goes to trial. Let's get into it. Okay, so to start, as always, if you are new to this whole saga, there is a playlist linked in the description below to a whole bunch of videos that we've made on this subject to get you caught up. And if you haven't seen the new evidence that's recently been revealed, I have a link directly to that video so that you can see everything that I'm talking about. Other than that, if you're still here, I assume that you already know about the SEC and FBI investigations. And with that, let's dive in after we hear from this video sponsor.
This video is sponsored by Upside. Upside is a free app that gets you cash back on daily essentials like gas, groceries, and dining. These are purchases that you're already making. Just open up the app, search for the restaurant, gas station, or grocery store, and claim your offer. Then you make your purchase, paying with your usual credit card or debit card. After that, you follow the steps in the app and you get paid. There are over 100,000 places that you can use this app with. Examples of participating gas stations are Phillips 66, Shell, Valero, Circle K, Marathon, Chevron, Exxon Mobil, and more. And for restaurants, you can claim offers for places like Chipotle, Papa John's, Dairy Queen, Domino's, Marco's Pizza, Arby's, Checkers, KFC, and more. I love going to this one Vietnamese restaurant when I'm back in Southern California to visit family, so I was thrilled to see that I could claim an offer there. So I treated my parents to some pho recently, and it worked beautifully. They got free dinner, and I got 6% of my purchase back just for using the app. There was no weird reward system or complicated points or credits that needed to be used. So all in all, a good user experience. To find out how much you can get, click the link in the description below to download Upside and use code Legalbytes to get an extra 25 cents back for every gallon on your first tank of gas. Or scan the QR code right here in the corner of the screen to claim this offer. And thanks again to Upside for sponsoring this video.
Okay, for real now, let's get back into it. Now, generally speaking, I talk a lot in a lot of these videos about how a particular piece of evidence might be terrible for one party in a particular case. And the focus for me typically is, how is this going to play out at trial? And the reason for that is because every single case that gets filed in court is aimed at making it all the way to trial. As a litigator, if you're not thinking about that end state from the very beginning of the litigation, regardless of whether you are on the plaintiff's side or the defense, you are not putting on the most strategic case that you can. And of course, when we're talking about civil litigation, the vast majority of these cases do not make it to trial. They either get dismissed at some stage or they end up settling at some point. But even in those cases that do settle, it's still important to know how the evidence stacks up and how things might look to a potential jury at trial. Let me put it this way. When you go to trial, you end up with a verdict. That is one side fully winning on an issue and the other side fully losing on that issue. The jury points to one side and says, you win, and they point to the other side and say, you lose. In other words, every case that actually goes to trial is a gamble. And while both sides are obviously hopeful going into the trial that they'll win, one of them will walk away losing that gamble. And so that's why a lot of these cases end up settling. So before a case goes to trial, when the two sides are entering into settlement negotiations, both sides are basically measuring up a number of things. First of all, there's the cost of litigation. And that's not just financial costs, by the way. They're paying for attorney's fees and litigation costs and whatnot like that. There's also a personal cost, time away from work, the stress that can impact a person's health, a person's sleep, the stress that can impact a person's relationships with their partners, with their kids, with their parents, with their friends, you name it. And then, like I mentioned earlier, there's the risk of potentially losing at trial, or maybe put another way, the likelihood of success at trial. So as you're litigating a case, even at settlement negotiation, it is crucial to understand how the evidence and sometimes other factors as well might impact the case all the way at trial. Because if the evidence stacks up really nicely, showing that you have a strong likelihood of success at trial, that means you have more power to negotiate a settlement with terms that are more favorable to you. And likewise, if the evidence is stacking up better for the other side, that's a sign that maybe you should settle, and it might be worthwhile to give in on some of the terms that you can live without so that you can walk away in as good a situation as possible under the circumstances. So that's why even if this case doesn't end up going to trial, it's still important to look at these various pieces that are coming out and to analyze how they might look at trial. So setting aside the whole explanation, here's why I think this evidence looks terrible for Logan Paul if this case goes to trial. Let's focus in on the SEC and FBI investigations. Now, obviously, neither of these investigations have resulted in criminal charges, at least not at the time that I'm recording this video anyway. And to Logan Paul's credit, that is an important detail that is helpful for him. And he does say that he was notified by the SEC that their investigation has concluded. So this means that the Department of Justice will likely not be charging him with any federal crimes related to the SEC's investigations into CryptoZoo or DinkDoink. Now, any reasonable person, of course, will look at that and say, okay, that went nowhere. And a person can reasonably infer that this also means that the SEC didn't find enough in their in-depth investigation to charge him with anything. That is absolutely true, and it could at least hypothetically be the reality in any case like this. An investigation is obviously not a conviction, and even an indictment doesn't mean that someone is guilty of a crime. That's what a criminal trial is for, after all. However, although the fact that the SEC closed out their investigation can potentially mean that there's nothing there, so to speak, it still doesn't automatically mean that Logan Paul is therefore exonerated. And that's especially because there still is an open FBI investigation that is apparently still actively looking into Logan Paul's activities related to CryptoZoo. And then you can also factor in the SEC policy change that came with the new presidential administration earlier this year. According to the article that Coffeezilla cited in his reply to Paul's opposition to Coffeezilla's motion to transfer, the Justice Department is no longer pursuing some crypto cases that they say are better left to other agencies. And apparently the SEC has actually dropped more than a dozen cases against crypto firms since the change in policy. Now, in all transparency, because I am going to show any strengths and weaknesses that I see here, I will note that there is a weakness in Coffeezilla's argument related to this particular article. Specifically, the article says that the SEC is recentering focus to be about victims and fraud instead of these technical violations. And they indicated that this was intended to allow the DOJ to devote resources to protect victims of cryptocurrency-related fraud and manipulation. And to be honest, it sounds like this policy shift might actually put more of the SEC's focus on a case like Logan Paul's. But then again, this article also isn't speaking to the specific case of potential criminality of Logan Paul and the other guys that came out with CryptoZoo. This is talking about a general policy shift, and what's important about that is the fact that it presents a possible alternative explanation for why the SEC closed out the Logan Paul investigation. And so now we can look at both sides arguing over what it means that the SEC investigation took place and ultimately was closed. And both sides have their clear positions. However, none of us, not even Coffeezilla or Logan Paul, really know why it was ultimately closed out by the SEC. Only the SEC knows. So we don't know if they found any wrongdoing, and we don't know if they found tons of wrongdoing, but decided, hey, this is the era of Doge, and we don't want to create more overlap between agencies, and we know that the FBI is still investigating this, so we'll let them handle it moving forward. Either of those is honestly a possibility at this point without more information. But that still gets me to my first big point here, and that is there is still an open investigation by the FBI. Logan Paul can say that it's quote-unquote dormant all he wants, but he really has no idea what the FBI is doing. I mean, since when does the FBI, or let alone any federal agency for that matter, give comprehensive updates about an investigation to the person that they are actually investigating? That just doesn't happen. And we've also seen in other cases that sometimes the feds will take their sweet time probing into the activities of an individual, and the public will hear absolutely nothing for months on end, leaving everyone wondering if they even found anything, only to hit that person with some very heavy charges a bit later. Side note, people have been asking me in the comments to talk about the P. Diddy trial. I've only been lightly following it, but if you're interested in hearing some thoughts on it, let me know in the comments down below. Lately, I've been moving back away from criminal cases and towards civil litigation because it seems like viewers prefer to see those kinds of topics here. But if there's enough interest, I will definitely consider looking into it to see if I can give some thoughts. But anyway, with that aside, my point here is that just like we don't know why the SEC closed out their investigation, we also don't know why there hasn't been any sort of like outward sign of movement by the FBI in their investigation into Logan Paul. The fact that he hasn't heard anything from them apparently doesn't mean that they're not actively investigating this case down some other path. And the thing is, unless the FBI closes out their case without any formal charges, this investigation is damaging to Logan Paul's case for a number of reasons. And that's true whether the defamation case goes to trial before or after hypothetical criminal charges are filed as a result of the FBI's investigation. For one thing, and I've talked about this a little bit before, there is this question over whether Logan Paul would testify in his own defamation trial. Let's assume for a hypothetical that this defamation case goes to trial while there's either an open FBI investigation that has not had any kind of conclusion, or charges have actually been filed against Paul and there's a pending criminal trial. I've said before that because he is the plaintiff, he's the one that brought this case, Logan Paul kind of has to testify in the defamation trial against Coffeezilla if he's going to be successful at asking the jury to make Coffeezilla hand over a bunch of money to him. Now, there's no rule saying that he needs to testify, of course, but remember, Paul is the one with the burden of proof in this case. And so he really needs to deploy anything and everything that he can in order to convince the jury to side with him on this issue of whether Coffeezilla defamed him. And if the plaintiff doesn't testify at trial, that creates a massive uphill battle for him. I'm not saying that Paul can't win under those circumstances, but the odds of success are pretty dramatically reduced. If Logan Paul doesn't testify, but Coffeezilla does, that's a huge advantage to the defense in this case. But now we have a situation not just where the weight of whether Logan Paul testifies is carried by those advantages or disadvantages in this trial, but there's also the fact that in order to testify in the defamation case, Logan Paul would need to waive his Fifth Amendment right against self-incrimination. And that's because so long as the FBI has an open investigation or they've filed charges and they haven't gone to trial yet, there is a very real threat of possible criminal liability hanging over Logan Paul's head. And so anything that Logan Paul says in the defamation trial can and will be used against him in any potential criminal trial that follows the defamation trial because it's covering essentially the same basic nucleus of facts. And when you look at the scope of what Logan Paul would have to testify about, absolutely the question of whether he actually defrauded CryptoZoo investors is going to come up. And that's because Coffeezilla is entitled to put on evidence so that he can prove the truth of his allegedly defamatory statement as a defense to defamation. Remember, truth is an absolute defense to defamation. So if the statements in question are essentially Coffeezilla called Logan Paul a scammer, he is allowed to put on evidence showing that Logan Paul did in fact scam people. So if this case goes to trial, we should see Coffeezilla absolutely explore that issue. And so bringing it back, we have this choice that Logan Paul would have to make. On the one hand, he can testify in his own defamation case. On the other, he can invoke his Fifth Amendment right and refuse to testify. If he chooses to testify, he's able to communicate his side of things directly to the jury and potentially aid in proving his own civil case. Now, there's other pitfalls to include those scummy text messages that are almost definitely bound to come up. But realistically, even if he doesn't testify, there's a good chance that those can come in anyway. And then if he doesn't testify, then he isn't able to explain those away. But if he does decide to testify in the defamation case, that is a massive massive risk because he's opening himself up to questioning that directly implicates potential criminal liability against him. Massive risk. Any lawyer looking at the situation would be waving all the red flags and being like, don't do it. Even if he thinks that he did nothing wrong, there's always a chance that he says something that says otherwise to the feds. And on the other hand, if he does invoke his Fifth Amendment rights and he refuses to testify, he protects himself somewhat on the potential federal criminal case front. But like I said before, he makes it that much harder to actually win this civil case. And now we also have to think about how else it might impact the jury if he does decide to invoke that Fifth Amendment right. To be clear, a witness's invocation of their Fifth Amendment right does not mean that the witness actually committed a crime. And so if he hypothetically did invoke his Fifth Amendment right, the judge is going to instruct the jury that they are not to draw any negative inferences of criminality by that. But if you take a step back and look at this more holistically, Coffeezilla wins if he proves to the jury that Logan Paul did in fact defraud CryptoZoo investors. But that's not the only way that he can possibly win here. He also wins if he can show to the jury that at the time that he made these allegedly defamatory statements, Coffeezilla reasonably believed that Logan Paul had actually defrauded the CryptoZoo investors. And if you think about it, if Logan Paul invokes the Fifth Amendment, he is not admitting guilt of some kind of crime, but he is saying that he has a reasonable concern that his statements could incriminate him when talking about the CryptoZoo project. And that actually kind of means even Logan Paul is feeling like there's a shadow of possibility that he could get convicted of fraud. Which means the jury might look at that and say, so if Logan Paul sees a possibility that he could get convicted of fraud, it's reasonable for Coffeezilla to have thought the same thing. And that would get in the way of Logan Paul being able to prove to the jury that Coffeezilla made these alleged statements with actual malice. And actual malice is an essential element that Logan Paul has to prove in order to win this case. And so that would mean Logan Paul loses the defamation case. So on the one hand, Logan Paul obviously knew about the FBI investigation into him when he decided to sue Coffeezilla. And considering everything that I just laid out, in my opinion, that's just insane that Logan Paul decided to still move forward with suing Coffeezilla when he is still under this shadow of threat of potential criminal liability. And if I were Logan Paul, I would want to see the FBI investigation closed out without formal charges before this case goes to trial for all the reasons that I just laid out. Who knows if that's going to happen? And even still, just the existence of these investigations either way helps Coffeezilla. On the one hand, you have obviously the possibility that they lead to criminal prosecution and even potential criminal conviction. That's a very real possibility at this point. And if that happens, boom, Coffeezilla has a very easy time proving the truth of the statements that he made, saying that Logan Paul scammed the CryptoZoo investors. But even if both the SEC and FBI investigations close out without any kind of formal charges, like I said before, Coffeezilla has multiple ways to win here. And that includes, like I mentioned before, convincing the jury that at the time that he made these statements, he reasonably believed that Logan Paul had actually defrauded the CryptoZoo investors. And even just the fact that the federal government found enough probable cause to continue investigating through search warrants and even grand jury testimony subpoenas and even a deposition, all of that is helpful to Coffeezilla. That's because Coffeezilla was a whistleblower in all of this, and so he ostensibly knew that all of this was taking place. And that is all information that he arguably reasonably relied on when making the statements that are at issue in this case, which again means no actual malice, and Logan Paul loses. And now there are also other reasons why this evidence is bad for Logan Paul. I've talked before about the fact that there's already this narrative that's presented itself in this case where Coffeezilla is the scrappy investigative journalist who's trying to be a voice for victims of crypto fraud, and Logan Paul is essentially Biff Tannen, a highly reactive bully who's obsessed with his perceived nemesis and wants to retaliate against Coffeezilla for ratting him out about CryptoZoo. And so from the beginning of this litigation, it's been the case that Logan Paul had this potential motive of retaliation for the public backlash that he received over Coffeezilla's original 3-part YouTube series. But now there's added fuel to that fire with the revelation that Coffeezilla didn't just out Logan Paul to the public. He also specifically outed him to the feds. And Coffeezilla's argument that this whole litigation is just retaliation is only strengthened if he has evidence that Logan Paul knew that Coffeezilla was the whistleblower before Logan Paul ultimately sued him. And remember, Paul waited well over a year after Coffeezilla came out with his 3-part series before suing him for defamation. He waited long enough that the statute of limitations already passed to be able to sue over those original videos. So he had to find other follow-up statements Coffeezilla made to sue him over those statements instead. And so if it turns out that not only did Logan Paul know that Coffeezilla was the whistleblower before suing him, but that he found out that he was the whistleblower after the statute of limitations had passed on the statements that Coffeezilla made in the original 3-part YouTube series, it can definitely make that look like Logan Paul wasn't planning to sue Coffeezilla until he found out that he was a whistleblower and decided to retaliate against him for blowing that whistle. Just in terms of potential narratives that are at play to the jury, this is another plus for Coffeezilla. But those are my thoughts. What do you think? Do you think that Logan Paul really was trying to hide all of this evidence from the public? Do you think these investigations look as bad as I think they do? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.